Today, I will be discussing an important legal case in Canadian law, Malette and Shulman, decided by the Ontario Court of Appeal in 1990. This case is very important because it centered around the issue of medical consent, particularly the right of a patient to refuse medical treatment. So what happened? The plaintiff, Malette, was involved in a serious car accident and was taken to the hospital unconscious. A nurse found a card in Malette's purse stating she was a Jehovah's Witness and that she did not want a blood transfusion under any circumstances. Dr. Shulman, concerned that she was in critical condition and needed a blood transfusion to survive, proceeded with the treatment anyways. And even when Malette's daughter asked the doctor to stop the transfusions, he continued the treatment anyway. When Mrs. Malette regained consciousness, she learned that the doctors had administered the transfusion despite her wishes. She filed a lawsuit against the doctors and the hospital, arguing that her right to refuse treatment had been violated. The question at the heart of this case is whether the doctors had the legal right to administer the transfusion without Malette's consent, especially in light of her religious objections. The defendant argued that the transfusion was necessary to save Malette's life. He claimed that in emergencies, healthcare professionals are legally permitted to act in the best interest of the patient, even without explicit consent, if they believe the patient's life is at risk. While this may be true, doctors are not allowed to give any treatment that a capable adult has refused, which is what happened in this case. But the doctor also argued that the card may not have expressed the patient's current wishes and that the card may have been signed because of family or peer pressure. The Court of Appeal, however, ruled in favor of Malette. The court emphasized that the principle that a competent adult has a right to refuse medical treatment, even if such a refusal could result in serious harm or death. This decision reinforced the idea that individuals have the right to make decisions about their own bodies and medical care, as long as they are mentally competent to do so. What made this case particularly important was that it established a clear legal precedent that doctors cannot override a patient's decision just because they believe the treatment is necessary. The court recognized that respecting a patient's autonomy is a fundamental part of medical ethics. In other words, a patient's refusal of treatment, even in an emergency situation, must be respected unless the patient is unable to make an informed decision, such as in cases of unconsciousness where the patient has not expressed any prior wishes. This ruling set an important precedent for patient rights and medical autonomy in Canada. It established that medical professionals must not only inform patients about their treatment options, but also respect their wishes, even when those wishes conflict with medical advice. All in all, this case reinforced the principle that individual autonomy in healthcare decisions is paramount. So, how does this impact an individual in the healthcare system, like you or me? Malette and Shulman is important for us because it highlights the importance of our autonomy in healthcare. Even if a patient is unconscious or unable to provide immediate consent, healthcare providers must respect their prior decisions. The case serves as a reminder to make sure that your medical preferences are known and respected, even in the event that you're unable to speak for yourself. Doctors are very highly respected in our society, often put on a pedestal above the rest. But no matter how good or smart your doctor is, your autonomy is to be respected above any decision they think is best. If you, like Malette, have an objection to a particular medical practice, make sure you have documentation on you for emergencies, just like the one seen in this case. That way, if your doctor decides to ignore your likely stupid and misguided wishes and saves your life, you can get back at them for doing such a terrible thing. So what does this mean for the healthcare system overall? Well, doctors have to respect people's wishes and can't just go administering treatments all willy-nilly. This is a good thing as it respects our right to autonomy. Our healthcare system should be doing a better job of documenting our wishes as to limit any confusions in potential emergency situations, like in this case. But I think this is not all sunshine and rainbows for doctors out there. From a medical perspective, they often do know what's best. Obviously, they shouldn't be able to override wishes of a capable person, but I can sympathize with Dr. Shulman in this case. If I was faced with the same dilemma as him, I would also struggle to let this poor person die, knowing I could do something about it, especially when it could be argued that their wishes might be considered unreasonable. In this case, Dr. Shulman could be thinking about the fact that this is a specific branch that interprets this one passage of the Bible in a certain way. From the same book, that said a man shall not lay with another man, lest he be stoned. And also, Mrs. Malette might only have this card because a person in power at her church told her it's the right thing to do. If I was Shulman here, I would probably think of some of these things before blindly following the card in her purse telling me not to save her life. In any case, I would likely feel bad about my choice. Hopefully, there's some kind of support system for these situations where the law and the do no harm vow seem to clash. And if there isn't, there should be, because doctors are humans too, and I imagine facing difficult ethical questions like this could wreak havoc on one's psyche. But anyway, Malette and Shulman is an important case that every Canadian should know about and think of. Thanks for watching.